Hi, I'm Ashanika, and today I'll be speaking about retributive theory of punishment. So, before we get into this theory of punishment, let us understand what punishment is. So, when you commit a wrong, you have to pay a penalty for it, and that penalty is known as punishment. So, for example, you have broken a glass, and your mother tells you that today you will not get even any evening snacks. So, you are deprived from that evening snacks, and that deprivation is known as punishment. So there are different categories of punishment that have been broadly classified according to their objectives, and they are known as theories of punishment. So there are 5 theories of punishment. They are deterrent theory, preventive theory, reformative theory, retributive theory, and compensation theory. So we will be looking into the retributive theory of punishment. So now you've heard the phrase that you reap what you sow, or jaisi karni vaisi bharni. So the retributive theory of punishment is based on the foundation that individual who commits crime should be punished according to the severity and proportionality of the crime. This is because it is believed that criminals should be exposed to that degree of pain and suffering what he inflicted to the victim in the situation. So it is a payback form of punishment. The application of retributive theory of punishment seeks to achieve a sense of social security and also set an example for others for not committing that crime. So now let us understand the position of this theory in India. So in India, the criminal justice system follows the reformative theory of punishment. The justice system believes to abhor the crime and not the criminal. This theory of punishment in India incorporates a simple rationale that antisocial elements in the society require to be coerced by the arm of the constable and at times by the rigor of the bars. But there are some instances where the criminal offense is so grievous that strict penalties are required for it, like the offense of rape or rape and murder, acid attacks. They require a strict penalty, otherwise the justice system will go haywire. So the Supreme Court in the case of State of Punjab versus Rakesh Kumar was of the opinion that sentencing process should be stern where it should be and tempered with mercy where it warrants being. Otherwise, departure from just dearest principle results into injustice. This theory has also faced a lot of criticisms. So in the case of Vishnu Shaw versus West Bengal, Justice Chenappa Reddy was of the opinion that retributive theory is incongruous in the era of enlightenment. It is inadequate as a theory since it does not attempt to justify punishment by any beneficial results either to the society or to the persons punished. So in multiple instances, Indian judiciary has addressed and dealt with retributive theory of punishment and discussed about its nuances and consequences. So in the case of Lena versus State of Haryana, the Supreme Court held that the principle of proportion between crime and punishment is a principle of just duress that serves as the foundation of every criminal sentence that is justifiable. There are many cases which have dealt with retributivism and some where the judges have highlighted and mentioned about the theory and its application. So there cannot be strict boundaries fixed for the application of different kind of theories of punishment. It is the responsibility and duty of the state and the justice system to ensure how effective a system can be built which upholds the public trust with it. Thank you.